afternoon, everyone. Welcome to the special presentation for the DC Court of Appeals on innovations in mediation and arbitration. We're very pleased to have with us several speakers this morning who are incredibly experienced in the field of international and domestic mediation and arbitration. To my left, we have Lisa Richmond from McDermott, Full and Emery. Next to Lisa is Mr. Michael Lewis from JAMS. We have Ashok Manukin from Three Crowns and Tom Allen from Greenberg Trauer LLP. We'd like to go and start by asking each of our panelists to give a brief description of their practice for some context and to give a little bit of a comparison of mediation and arbitration and when you would use either tool in your practice from a strategic standpoint.
Can we get started? Sure. Okay, so my name is Lisa Richmond. I'm a partner at McDermott, Full and Emery here in Washington, D.C. I'm a native Washingtonian. Very proud of that fact. My practice is split between principally international commercial arbitration, some amount of domestic arbitration, some amount of investor-state disputes, typically in the arbitration context, and then I also do mediation and litigation work around the world, principally as counsel. I speak a few different languages, and that's how I sort of fell into the world of international disputes. As a very young associate, every time someone would say, oh, I need a translation of this document, because usually on a holiday, I'd say, absolutely. Or I'm speaking in Paris next week. Can you put together some slides for me? Yes, I'd be delighted to do it. So because I had this sort of characteristic of always saying yes, one of the first things that I said yes to was an arbitration as a very junior lawyer. The domestic arbitration, I didn't know anything about it, but it sounded really nice to be able to throw the rules of civil procedure out the window because I didn't care for those. So I worked on that arbitration because of that experience and because of the somewhat luck that I had that the other associates who happened to be working on that case left the firm that I was with before we went to hearing. I ended up doing an opening statement before I'd ever seen one in arbitration. I did cross-examinations, and so I got exposed to lots of arbitrations after that because I had a low billing rate and experience. So that's how I sort of fell into what I do now. I think it's fascinating. In terms of your question about when would I mediate versus arbitrate, I can't say that there's a one-size-fits-all to answer that question. In fact, often you will sort of find yourself starting in a dispute or giving a client strategic guidance about what should they do and end up shifting course. So, for instance, I can think of a matter recently where the contract called for litigation, but where we ultimately were able to get the other side to agree to mediate, particularly because we had some very sort of different understandings of what was going on in the dispute and thought that it might be useful to have a neutral third party who could tell us about what they thought a judge might do, help the parties to try to reach some common ground. But that's sort of just an example, and I'm sure we'll talk about many more.
So I'm Michael Lewis with JAMS in Washington. I'm a mediator and arbitrator. I do much more mediation than I do arbitration, although I do some arbitration. I do virtually none internationally. I occasionally have a mediation here in which one or more of the parties are from someplace other than the United States. But I didn't get to the point of getting enough languages under my belt so that people call me to do arbitrations in Paris. I am also a native Washingtonian, so there are probably not very many panels where you have two in a row, right? So that's a good thing. And I just wanted to observe, actually, this has nothing to do with the panel, but you know you're in a court of appeal when you walk up to the security officer who looks at you and says, "Good morning, multi-purpose room." That would never happen across the street. So it sort of feel very rarefied here. I've been mediating since 1972, 73. I started started working at a nonprofit organization about the same time that I started law school. A few months before I started law school. This was my second career. My first career was in the Foreign Service. And we were then experimenting because in 1973 and 2, if you said to a lawyer, "You're a mediator," they look cross-eyed and then they say, meditation? What did you say? Mediation?
Mediterranean.
Yeah, Mediterranean maybe. There was just no general understanding of what that meant. And so the world has changed enormously in the last 40 years. And I don't have any clue about the answer to the strategic question because I'm on the receiving end of the decisions that have been made as to what parties are going to do. And the arbitrations I do I can't think of one that wasn't before me because of a contract between the parties. And so they're often stepped processes in contracts now, and that is a fancy step process might be, we agree we're going to negotiate, and then if that fails, we agree we're going to mediate, and maybe there's a provision that says we bring in people higher in the organizations to be involved in the mediation, and if that fails, then we go to arbitration. So occasionally, I get arbitrations where parties have blinked twice, and that was their mediation, and they end up in the arbitration, and then sort of midway through, they start scratching their heads about why they're there and why they hadn't tried mediation. So that happens sometimes, not with me as the mediator, but they sometimes say, "Can you find us a mediator?" Because we've gotten in a place where we don't want to be, shouldn't have been, should have just followed the clauses and mediated, and we probably would have, maybe, might have gotten this result. So, stop there.
I'm an exception. I'm not a Washingtonian.
Your name?
Yeah, my name is Mushek Malukia, and I'm an associate in the Washington, D.C. office of the Crown. I'm not Washingtonian, so that's an exception. I'm not sure if it's a good thing or not. But, so I do primarily international cases, and those cases are commercial arbitrations and investor-state arbitrations, pretty much aligned with business practice. And I do mediation with the court and some other practice. Probably the last 10 years I've mediated about 100 disputes, and some of them in the court, and it has been just an excellent experience. So what I will say, and I will talk about the trends and where probably the practice is going, but I think one thing that I should note in terms of how we choose when you're acting as counsel, how you choose mediation versus arbitration. And sometimes you will end up into arbitration because the contract provides, as Michael was saying, then you will figure out whether the proper way of resolving the dispute is negotiation or mediation. But there are certain cases that I would probably recommend to clients to mediate or negotiate. So one of them would be when there's a potential for the continuation of the relationship. So for example, if there is an ongoing project, you don't want to stop and arbitrate and then you destroy the entire project because parties wanted to fight. There's one case that you would probably recommend to go to arbitration or litigation when one party fiercely wants to retaliate against the other party. Then likely they will not accept to mediate or settle it. And in investor-state context, there are certain disputes I very much encourage, and maybe we'll talk about the trends Now investor-state mediation is becoming a trend, and hopefully it will find its place in the international dispute resolution space. But I will say there are certain disputes that likely will not be able to be resolved through mediation. One of them would be when you have a binding court decision, and just as a context, investor-state disputes are those when an investor sues a host government under international law, and sometimes you will have a court decision which will amount to allegedly denial of justice, meaning that the court did not do its job, and therefore the investor's rights are violated, and the investor will go to international arbitration. In those cases, it's difficult to mediate, because even if you try to do it, the government typically mediates, and the government will not be able to tell the court to change the decision because you have separation of powers and all kinds of things, and you break the separation of powers if you do so. There are certain other things. I had a case representing Bahrain, and it's public. There's a Washington Post article against 2 Iranian sanctioned banks. I would hardly imagine this dispute could be mediated because there's a tension between Bahrain and Iran. And it's very difficult when the tension is high, there's political issues, you would mediate those disputes. I think, but there's probably a better chance if your counsel is oriented towards mediation and you have the right people in the room to make the business decision to mediate, go towards the mediation.
Great. My name is Tom Allen, and I'm a shareholder at Greenberg Treurig. I do international arbitration. I'm kind of an Asia specialist, so it's rare for me to be in Washington, D.C., but I have to come here more regularly because my kids have started calling me Tom, and that's never good. So I'm repairing my family relationships, but also privileged to be here today to talk to this group. You know, I started as a court litigator. I think a lot of folks that get into arbitration start as court litigators. My very first case was in the federal court around the corner here on Constitution Avenue, maybe it's this way. And that case got kicked and went into arbitration because there was an arbitration clause. We then appealed to the DC Circuit and got the case sent back to the district court. And when we got back to the district court, our opposing party filed for bankruptcy. So my very first case ended up in 4 different places. So eventually my career kind of evolved to the point where I was only doing international arbitration, not because I don't like my children, but because I found it very interesting. And you know, arbitration is a feature of contract, and parties have all sorts of different reasons for wanting to arbitrate a case. The biggest one usually is that they want to ensure a neutral forum because there's parties from different places and they don't want to be in the other party's backyard. They also want to have a say in who hears the dispute in a courtroom. It's more, excuse me, a random thing as to who will hear your dispute. And they often want confidentiality of proceedings. But there are, you know, and the question of when to mediate, when to arbitrate, is really before, after, or during. You can mediate at any time. Parties often like to mediate before a dispute formally begins, before positions harden. When the first time someone files a paper, positions start to harden. The first time you see someone write something that says bad things about you or your company, then positions can harden. Oftentimes people like to get in, have a third party look at the case, sit down, try to talk them through a settlement before they get to that hardening of positions. Sometimes people mediate in the midst of their dispute. They realize this is going, you know, one way or another, or something we didn't expect. They're original, it's taking too long, it's costing too much money. We need certainty. A lot of businesses require certainty for their planning purposes. They'll say, let's take a step back, let's do mediation now during the midst of our proceedings. Most judges, most arbitrators are willing to grant a pause in the proceedings to see if the parties can work something out. And then often, when the end of the proceedings, You know, again, things have changed. Maybe my view of my client's position has changed at that point in time. Maybe the other side says, geez, we really got killed in that arbitration. Maybe we should talk mediation at this point. You know, there are no right or wrong answers as to when you begin. I think that the goal of all of this is coming up with an efficient way to resolve your dispute. And there are many ways that people think are efficient, and mostly they think they are inefficient. But you know, those are conversations that I think you have throughout the time of your dispute as to where you want to be and how you want to approach things.
So it sounds like you all are coming at the mediation and arbitration processes from different perspectives, both as neutrals and as practitioners. And I'm wondering, what new creative tools are you seeing, and where do you see mediation and arbitration developing in the next couple of years?
In the next couple of years, I don't know that there is a single answer. At least domestically, the federal government was doing some very interesting things with mediation for a while. I think it's fair to say that while stopped at least about 3 years ago. And so agencies like EPA have had quite active programs to try and resolve various kinds of environmental disputes. I don't know that they're doing anything in that regard now. If they are, they're not doing very much. Courts, many courts have said, have announced that they have mediation programs, and many of those programs, unfortunately, are virtual Potemkin villages. There's sort of nothing behind the facade. There's no one to manage the program. And so that's not a hopeful sign. And part of the problem has been that some courts have embraced mediation because they've got these huge backlogs and they know what to do, and they say, well, let's create a mediation program because we don't have any resources, and so they don't put enough resources in supporting the program, and so backlog here, not a very good program here, and it doesn't add up to very much. And so I don't have a crystal ball about the future. My guess is that both mediation and arbitration will continue to grow, partially because, as Tom said, my experience is businesses do not like the uncertainty of lawsuits. And sometimes they have to engage in them, but the notion that we don't know what's going to happen here, we're trying to plan our budget and what we're going to do and how we're going to do things next year. It's really unsettling. I mean, in fact, for me as a mediator in a dispute in which one side or both sides are business people, I mean, one of the questions that gets their attention is, do you want to spend the next 6 months of your life sitting down with Tom and figuring out, or Lisa, and figuring out, what you're going to do and how you're going to do it, and not running your business? That's not attractive, right? They didn't go into business to be in disputes. They wouldn't go into business to make their widgets or whatever it is that they make.
Most clients say to you at the end of a case, thanks for your help. I never want to see you again. and it's true, because nobody wants to spend too much time with a litigator or because we charge by the hour mostly. In terms of where things are going, I think it's interesting. Doing a lot of work overseas, I work in a lot of places. I spoke in Thailand recently. I'm speaking in Japan next month, where the systems of building alternative dispute resolution are more in their infancy. they are not as well developed as they are in the United States. And I think the first question of where are we going, you have to look at where are we. You know, in the US, I think we have lots of systems that are in place in different courts in the country, lots of private entities that are engaged in the business of arbitration and mediation. And so the users or the potential users are comfortable now, for the most part, with the processes. And now they're looking for, I think, you know, what else can we get out of this? There's been a push towards lower dollar arbitrations. Can we do them in a completely different way? We see, you know, eBay arbitration now. We see online services being offered that have the same legal protections as if you were using, Michael, at JAMS under the Federal Arbitration Act or the Uniform Arbitration Act. And so the evolution there, now that the users are comfortable, I think is more towards how do we make it more efficient through using technology, through, you know, through recognizing that we all maybe don't have to be in the same room, and we don't have to make, you know, reams of paper every time. We can do these things online. We can connect in ways that will get this done faster and still have the benefits that at the end of the day I've got, you know, a settlement agreement that's enforceable or an arbitration agreement that can be taken to a court and enforced. So, you know, there's, you know, as technology advances, I think you're going to see lots of interesting developments. There's even companies out there that are making, they say, robot arbitrators. Yeah, so you know, personally, I'm not thinking I need to look for a new job yet, but we'll see.
So one thing I would note in terms of international mediation, as many of you know, the Singapore Convention was adopted by now more than 51 states. On August 7th, there was another session at the UN in September, 5 more states joined. So that will bring a lot of change to international mediation. Maybe we'll not see that many enforcement actions, enforcing settlement, but it will definitely create more credibility for international mediation, and more people will start using international mediation because there is now an enforcement tool. Another change that I will say we have to expect at least in a couple of years, maybe less than 5, is around the investor state arbitration. And many states are now very disappointed about the system, and they want to create a new system. And one of them will be probably the European Union will create an investment court, which means that if those disputes in the past that were arbitrated, some of them, at least within the European Union, will go to this investment court. And now, a lot of states are proposing to have investor-state mediation. Indonesia recently proposed to have mandatory mediation for investor-state disputes. So my expectation, my hope will be that in the coming years there will be more investor-state mediations, and investment court probably will provide some tool within this court. There will be some tool to mediate disputes.
Also, as a court mediator, where do you see court-based mediation going in the next few years? That's for you.
So the courts, I would say, and I can talk about the international context. I've seen many courts, including in my region, where they will reach out and say, we want to establish court-annexed mediation. Can you help us? And the same will be court-annexed arbitrations. The challenge, at least in the developing countries, is how to sponsor, how to finance these programs. And you know, when you are establishing a new system and you put the burden on parties, people typically are reluctant to accept that system. So the states are now, I know the Netherlands government, the German government are doing something like sponsoring a year to say we have a system, we'll sponsor a year, but after that we have to figure out. So I think the court annex mediations and court annex arbitration will be a big part of it, but still international commercial arbitration will be, a lot of these people will be resolved without the court, so whatever we want to do. So that's probably domestic disputes that will go to.
And how about domestic disputes in the U.S.?
Well, I'm sorry,
development of court-based mediation programs in the U.S. You're seeing a lot of appellate courts that are introducing mediation programs as of late and expanding on existing court programs. And I know, Michael, you touched on some of the concerns initially.
Right.
With that in mind as well, where do you see things progressing?
My expectation is that there will continue to be interest in creating new programs, and my only concern is whether they will be supported properly. Actually, this morning, just before I came, I sent an email about a case that I'm mediating in the DC Circuit program, because I didn't have time to talk to people. I was on my way here. So, but I expect that those programs will continue to flourish. And I agree that there's interest in other countries, and my concern about resources in those other countries is more heightened than it is here. But I think there is interest, and probably in most cases, places where there's interest, there's very good reason for there to be interest, because those court systems themselves are struggling to deal with the caseloads. So, someone told me recently about backlogs in India, and they were horrifying numbers. And so, right, and so anything that might be done to help folks get some of their disputes resolved more efficiently than the current system is God's work, essentially, because they've had pretty much nothing if there isn't something else.
One last thing I should note around the kind of corporate disputes. I've seen many international organizations, such as the United Nations and such as the World Bank, now they are developing their own mediation programs. I know the United Nations is now launching the mediation program as of November 15, which will actually deal all internal employment law and disputes through the system. And the same World Bank is doing with the IFC's projects. When IFC is an investor in a project and the community is complaining about the pollution of this project or any other things, then you can actually refer your case to this institution and mediate your case. So these are type of things that I think in the next probably a couple of years we will see more international organizations pay more attention to mediation and settlement discussions.
There's something to add that I think is an important consideration. So I mostly represent companies, right? And companies are relatively equal bargaining power. That's not always the case in every contract, right? Oftentimes you have individuals going up against companies and, or employees versus employers. And I think it's interesting that in arbitration, if you've been following, the Supreme Court jurisprudence lately, they've been broadening the scope of arbitration in terms of who can be compelled to arbitrate. And it's extending now more definitively to certain types of contracts where, frankly, there is not equal bargaining power. And so that's a trend that I think we need to keep a close watch on, because while I might be an advocate of resolving disputes by contracts between parties of equal bargaining power, the court system, it shouldn't be lost in terms of what it may offer individuals in terms of additional protections, including appeals and things of that nature. Now, all of my clients, if they watch this, will say, don't say those things. We want to arbitrate with our employees. We want to, but it's something to look out, because, two big people going up against each other is a lot different, where you're bearing the expenses of the procedures, and you have to know a little bit about crafting what's going to happen versus an individual and those experienced counsel. So it's something that's important.
I actually have had experience very recently with two different disputes. There were streams of disputes, and they existed solely because the Supreme Court has said, our Supreme Court has said, You know, if there's no class action clause in this, then there are no class actions permitted. And so what has happened in at least 2 instances, recent instances that I know of, is that I think in each instance there were roughly 1,000 complainants who were bound by arbitration clauses, and they couldn't combine. And so there were 1,000 arbitrations going on, or begun in any case out there. And I don't know, in both instances, I don't know if any individual cases had gone through a hearing. I do know that in both instances that I know of, I didn't ever get to a hearing because the parties settled on a global basis. And I don't know how this, I don't know nothing about how the settlement occurred, but it was a natural consequence of the Supreme Court saying, oh, no, Tom's clients prevailed on that one. And so that'll be that sort of scheme will be interesting to watch going forward. I think we probably will see more of that than less, for at least a while, until the underlying jurisprudence changes.
Are there any other additional trends or creative approaches that we haven't touched on? Or what about selecting a mediator or arbitrator? There are a lot of folks in the audience who look at both of these types of ADR and say, how do I find the right person for what I'm looking for? What kind of qualities or attributes am I looking for in a mediator and an arbitrator? And I'm looking at Lisa.
Yeah. So again, I would say I think I tend to look at every case individually, but really at base, I'm looking for someone who I think is going to be really thoughtful, who's going to pay attention to the matter, have time to mediate or arbitrate it, to dig in and really try to understand what the claims and defenses are, whether it's in mediation or in arbitration, and someone sort of whom I trust to sort of thoughtfully approach it, rather than, oh, they have to have mediated 100 times, or they have to have specific pharma experience. And I regularly see contracts that have in them, the arbitrator must have 15 years of experience doing X, Y, and Z and have worked at blah, blah, blah. And every time I do, I say to that client, I didn't draft this for you, but let's have just a 5-minute lesson on what not to do the next time. So I'm about to tell you that there are approximately 5 people of whom I know who I think would fit this bill and maybe do it, and 3 of them are not going to be available because they're so busy, and not sure the other 2 are really the best for your case. Next time, I recognize that this makes you feel a little uncomfortable, but either try to be more specific from the perspective of, if there is someone whom both parties trust and is a trusted advisor who they both think is neutral, you could put that person's name in there. There is, of course, a risk involved with that, but that's being more specific in the sense that you know that it's not some magical unicorn that you think exists out there, but an actual human being. Or you leave it open. Because when you put in all of these qualities that this person needs to have, you really sort of hamstring yourself. And you make my job harder, because then I either need to find a creative way around it, which I've done, or I need to go and try and find that magical unicorn who I'm not sure is actually the best person to mediate or arbitrate.
I have gotten incredibly arcane questions asked about, do I know, and you think about it and say, is there a person in the world who has all these qualifications? Maybe there are 5, but unlikely. There may not even be 2. And it's not a wise way, I think, of choosing neutrals. takes you down rabbit holes that, and especially in mediation, having someone who is an expert in the subject matter can be a problem. Because if that person really is an expert, his or her inclination at some point in the mediation is likely to be, oh, I know how to fix this. And then to spend the rest of his or her time trying to sell the fix that, the expert has figured out is the way to do it. And it might be a way to do it, but to tell the parties that this is the way can be destructive. I have talked to lawyers who said, well, we had a day and we realized, the 2-day mediation, that our mediator had decided how this should be resolved, so we sent him home at the end of the first day, told him to get back on his airplane and go back to wherever he had flown in from. And then we proceeded to try and do it ourselves because he wasn't helping. So,
In that instance, what attributes do you think would be helpful to help parties resolve mediation? And I understand that you are on the other side of the table, Michael, but, and it goes to the whole panel, what things specifically do you look in your mediator? And it lets you know that that person is going to be the gentleman or the lady who's going to get it done for you.
We usually, we ask around a lot. So with mediators, we don't so much interview them, but we do with arbitrators if the dollars are significant enough. And most arbitration rules allow you to speak with your party-appointed arbitrators before you appoint them. For mediators, usually if I'm suggesting mediation, it's because, I think that the parties, in my usual situation, the parties haven't made any progress themselves, and you want someone to take a third party look at it. And what I'm looking for usually is a mediator who's going to get tough with the parties where they're weak, so that you can narrow the issues and get closer to a settlement. But also not be someone who, the type of rapport they can establish with the individual of each side, I think is very important, because you're going to want to be trusting them because you're candid with your mediators. You share.
But you should be.
Yeah, you should. You share a lot about your case. So you're looking for someone who's, who people have told you, if you haven't worked with themselves, has these types of qualities that you're looking for. And I've had, success and a lack of success, and a good mediator can make a big difference. But the best mediator in the world is also not going to be able to get where there's being at least one unreasonable party getting them together. For arbitrators, it's a different calculus for me. I want an arbitrator who is going to this is just a repeat, but understand my case, have the time to spend in the case, have at least enough expertise to understand my claims if it's a particularly complicated case. In international arbitration, you're oftentimes, and you hate to say it, looking for someone who's in the club, because the other arbitrators are probably also in that club. So you want someone who's got respect within the room. That's changing a lot because there's been a big push towards having arbitration panels be more diverse. It shouldn't just all be old white guys anymore. Where really, most of the major law firms are now taking pledges that they'll appoint, at least one candidate or other underrepresented populations in this field. So that becomes a different calculus, but it's something that arbitrators are becoming younger, and they're becoming more diverse, and they're becoming more reflective of what the parties are, which is a good thing.
And talk a little bit about what we look for in our mutuals. Flipping the table a little bit, what are some things that counsel should keep in mind when representing parties
in a mediation or arbitration proceeding, both from the news perspective as well as folks who've been doing this for a while as advocates?
I can speak about what I see as a mediator and in the court. A lot of times I think counsel doesn't get it. Like this is a different process versus litigation or arbitration. And particularly you feel it right away when you have received or written the mediation, confidential mediation statement. You receive it, it's exactly the same like the appeal. You say, no, I don't want this document, it's not helpful to me. I want the template that the court has provided to you, and if you could just, it's a 2-page document, and if you could do it, that'll be very helpful, and then we can discuss more in the confidential call that we'll have with counsel. That's getting prepared is very important. I've seen many lawyers come to mediation as, okay, I'll try it if my client wants it, and then I will go to do my job, which is litigation. And I think the lawyers who really take this seriously and prepare the needs and prepare and understand the needs of the clients, and BATNA, ZOPA, whatever we call it in negotiation teaching, understanding what happens if we don't sell it, what is the bottom line of the client, and everything, because you see a lot of lawyers coming into the room and they will start learning the case with you. So it's really good when you see a well-prepared lawyer. I think that's maybe the thing that I would highlight.
It's a different audience, right? So an arbitration panel is going to be different than a jury. Is going to be different than a judge in many cases. I had a big case a couple of years ago where a very talented lawyer who was used to presenting to juries went up from a prominent firm and acted like he was at a jury trial with the 3 arbitrators, with the hyperbole and the overstatements, and really misreading the fact that he had some of the most famous arbitrators in the world hearing the case and not realizing that this isn't a jury that more likely than not includes lay people who don't have legal training, who aren't experienced in resolving disputes. So don't do that, I would say. And there's some depending on the organization too, there are sometimes some clubby aspects to arbitrating and things like that. There's some unwritten rules. You probably want to figure out what those are. But for the most part, I think advocates just really need to try to maintain their credibility. Don't try to go too far in pushing points that you really don't have a lot on, and stick to your stick to what's in dispute and what's important for your case.
I would just build, I think, on what Lisa said about thoughtfulness and willing to commit the time. And in terms of what advocates sometimes get wrong, and I see less of it than I did 20 years ago, but the notion of how they prepare for a mediation. I once did a construction mediation in which someone said that he wanted to make a presentation, and I was not quick enough to ask him how long he thought this presentation was going to go. And that was my fault. His fault was thinking that it was a good idea to spend an hour lecturing to the other side. And you could see the curtains come down over, literally over their faces. They got more stony faced as his presentation went on. And that was it. That was basically, that case was never going to settle, at least that day with me as the mediator, because he had fundamentally misread what he, instead of trying to convince the other side, he was trying to bludgeon them into submission, and no one likes to be bludgeoned. Even if you don't have much to work with, you can still say no, right? And so it was just a fundamental misreading of what the mediation was about and what he might have been able to achieve. Now, I have no idea whether this case ever could have been settled anyway, but it certainly was not settleable in the way that he was approaching it. And I do see less of that nowadays. I wish I saw a little more of that I would leave an opening session with the understanding that the lawyer and client really had talked about why they were in mediation. I still see lawyers who don't have the kind of conversation with their clients about what they can achieve in the mediation and what's really in the client's interest, instead focused on what they might get in litigation or, depending on the situation, litigation or arbitration. And there is often a difference. And if you don't ask the questions of the client, then you're going to go awry because you don't really know what the client really wants. And that I still see, also less than I used to, but I still see it. And it's too bad because it's, despite the fact that the mediator has no power, it's an incredibly powerful process, as anyone who's been in a mediation or is mediated knows. And to throw away that power because you haven't really thought through what you should be doing is always sad.
I think that frequently starts even sort of 2 steps before then in terms of when you're thinking about, okay, what do we want this mediation process to be? Not having a good meeting of the minds between the parties as to, do we both think that an arbitrator who is going to, or rather a mediator who's going to be tougher on us is what we need? Or do we need someone who can hear out our gripes and let everybody have some kumbaya moments and then talk about, okay, well, now where can we find the middle? But what qualities do both parties agree is going to help to get? And that, of course, assumes that you have parties that are both really wanting to be there. And at least in my experience, oftentimes there's one party that really wants to be there, the other one's sort of going along with it. And that can usually result in the most successful mediation.
It's interesting too, because you're sometimes looking at, and I would imagine with the court programs, you have a diverse array of clients, but understanding what's important for your client. If your client's an individual, that might be an entirely different calculus than if your client's a company. I had a pro bono case, employment matter, representing someone one time where really, he didn't really want money. He just wanted someone to recognize his, that he believed he had been wrong, and he wanted to take the case up, and as high as it could go. And the thing that convinced him, because he was getting a sweetheart deal in terms of money and everything, but the thing that convinced him was that we had taken the case up on appeal to the DC Circuit and made some good law with respect to what's considered an adverse employment action. And when we told him, other people are going to be able to rely upon your precedent, that was it for him. It's like, make the deal. That's enough. So it's really, it can be personality driven.
Yeah.
And, I think a lot of those cases, are part psychologist, part, social worker, part, to understand what does the client really want and need, and then be able to, because it's not always just money.
So it sounds like part of it, at least with mediation, is looking for some creative solutions that might go beyond what a party's entitled to in a case. So how do you approach that with your client in preparation of that mediation? What kind of tools do you employ to do that?
In that instance, I just beat him verbally over it. Said, we can go to trial, we can win, we may not win, but you're gonna get less than what you're being offered now. And, you know, for me, when I say you need the mediator to be tough, sometimes you gotta be tough with your clients too. You gotta say, listen, our best case scenario is this, our worst case scenario is this. You know, it's unlikely we're gonna end up in either position, but, you know, understand what your risks are here, because the reason why we're talking about this is because they're not insubstantial. I mean, I wouldn't be here if I thought your case was a slam dunk winner. So, you know, sometimes the lawyers have to get tough with their clients.
So I just wanted to discuss the panel too, as a follow-up to what Tom was saying. In appellate mediation, which a lot of us here do, you're at a point where you convinced your client, maybe in the first part, that he had a slam dunk, but he lost, if you're the appellate. So how do you regroup with that client and come back and say, okay, look, didn't go our way this time, we're thrown into this appellate mediation. How do you work with the client to get them to be more accepting of the process and open to new ideas?
I can speak about it from the mediator's perspective. The program that the court has is just excellent because you have, in every case, you have to have a lawyer to be able to use this program. And every time lawyers come to mediation and they present typically a draft of the appeal as in the mediation statement. But what is important, a lot of people think that it'll be very difficult to mediate. I think it's true, it's difficult that it was, and I think Tom was alluding to it, that in the beginning it's easier because you have more room to negotiate. Now you have a judgment. It's now narrow settlement that you can reach. But I think what is important that it's the same process. And a lot of times I see lawyers, of course in corpus, typically telling me, yeah, we know we have won, but we know what could be in the next couple of days or couple of weeks. So we are willing to accept such a settlement options. So in that context, appellate mediation is probably the same as regular mediation, only you have some more boundaries to play with. And I think the role of the mediator and the whole counsel to be able to expand upon it, and I can say that all cases, I'm now trying to remember all my appellate cases, every case that I've done in the court, you would see that apart from that underlying dispute, there's some more relationships going on between the parties. And I think if the mediator can identify what are other things that you can bring to the table, then it becomes easier. And all cases that I've done here, every dispute has some other dispute between the parties. Whether you can mediate in that session or not, that's a different issue. But at least I think it helps when you expand upon and bring more issues and try to get a focus on it.
I think the paradox is, for mediators, the more issues on the table, the more likely it is that you'll be able to help the parties put this jigsaw together in a way that satisfies all of them or both of them. I used to do some family mediation and would occasionally have lawyers call and say, this was really tough, but we resolved 20 issues in this divorce, and there's one left, so we're going to send the parties to you. Little did they know that my incentive was to unbundle all those 20 that they had put together neatly in a package, because if I unbundled them, it was possible that we'd be able to deal with the 21st. But if we left the bundle like this, the one thing that was left out there was going to be really difficult. But that, you know, it illustrates the paradox there that sometimes the more issues we have on the table, the easier, or the more likely it is, it may not be easy, but the more likely it is that we'll be able to resolve everything, just because there are more trade-offs possible.
So we have a couple minutes left for questions.
Yeah, I wanted to go back to the investor disputes. Isn't there no a limiting factor in these mediation and investor disputes because of the political context in which a lot of those cases come up, that the government just can't.
I'm sorry, so they're having a hard time hearing you.
Oh,
Here,
sorry.
I'll do that.
I wanted to ask you about the investor disputes, and I wondered if, in many of the cases which are politically colored to them, the state really is not in a position to mediate, because they couldn't stand the press that would come out if they settled.
That's an excellent question, and I think not only political dimension of the dispute is very important to mediate, but also there was a case when the representative of the Bolivian government was engaging in settlement discussion, and she went back home with a settlement in her hands, and she got charged, and because people believed that she took some bribes to get the settlement. So a lot of government officials are afraid that when they settle, that it will be difficult for them to sell the settlement to the higher officials, or the president or the prime minister or the parliament. Another thing is very difficult to get the budget. It's very easy to sell to the parliament or whatever the budgetary authority is, to say, oh, we have a binding judgment from so-and-so arbitrator, we did our best to hire the best counsel. But now there's a mediation settlement proposal by a mediator. Can you please approve a budget which is fixed for every year, and you cannot find additional money? It's difficult. But if the states are committed, and it seems the recent conversations now that are taking place at the UN, particularly in the ASEAN, there's a working group now, they are trying to reform the investor state dispute settlement mechanism. They are proposing mediation as one of the alternatives to arbitration. And if they created tools so state officials will not be afraid, the political context can be minimized, and so on and so forth, then it will be easier to mediate. And some other states are putting down into their investment treaties. So which will create an obligation on the investor to try to mediate before going to arbitration.
Is there time for another question?
I was interested in one thing that you said, Michael, when you talked about the trend that you noticed with regard to the federal government using mediation. Last, you mentioned the EPA as an example, and then you talked about the court programs where maybe they have one, but the structure behind it doesn't support it as much. I haven't noticed that trend, by the way, so much with workplace mediation in the federal government, but setting that aside,
Right.
for the trend that you have noticed, I'm interested in what you think the reason might be. Is it that people don't want to spend the money? Is it that people don't think it has worked well? What do you think is the reason?
I think there's a general philosophy of, well, we don't like, this is all namby-pamby, we're not going to pay attention to it. But that's just a guess. I don't really know. The programs, there's some cyclical stuff that happens despite the existence of what appear on the surface to have been successful programs. For example, the Corps of Engineers had a fairly active dispute resolution structure for a while, and then it totally disappeared. Same thing happened at the folks who provide our electricity, the PJM connector or something like that. Anyway, PJM had a very active dispute resolution program. I did 4 or 5 mediations, and then one day I got a call saying, "Are you interested in being on our panel?" And I said, "Well, yeah, actually I am on your panel." "Well, no." It had disappeared, the whole thing, and I was stunned. It's an institution. What kind of memory is there here? It turns out there is none. They just put the whole thing back together again. So, I don't know how that or why that happens, but in those 2 instances, I know that it did happen, and each of the programs, so far as I could tell, were doing useful things and accomplishing the purpose for which they had been constructed in the first place. So, I don't know.
I'd really like to thank our panelists today for your time. And,
putting together this event. And thank you all for coming.
I know we have a lot of familiar faces in here. If you have not been here before, though, and are interested in mediation opportunities or our pro bono counsel program, please come see me afterwards. We have applications, and I can tell you a little bit about the programs. Thank you again for your interest in me about mediation.